Well, good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, October 6th. The time is 9:30 a.m. With us today are Commissioner Emily Lindley, and for our General Counsel's office, Todd Berkey. Commissioner Janeka is attending to family matters, and our thoughts are with him and his family. Today's meeting is a hybrid meeting, meaning most of the participants are joining us virtually. So please keep your, if you're at home or in the office, please keep your microphones muted when you're not speaking. And if you're here only to listen, you can watch the meeting online, and that link is available on our agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. For those who are making presentations, please wait until I or our General Counsel have asked you to begin speaking, and please remember to double check your microphone and make sure that it's unmuted before you speak. With that, I'd like to thank everyone for being present here in the room today and all those who are logged in. And with that, Mr. Berkey, please call the first item.
Certainly. Item 1 is the consideration of the proposal for decision and proposed order concerning the application by Jupiter Brownsville LLC for new air quality permit numbers 147681, PSDTX 1522, and GHG PSDTX 172. For oral argument, the parties have been notified that the applicant will have 10 minutes. The protestants collectively will have 10 minutes, and the ED and OPIC will each have 5 minutes of oral argument time. The protestants have indicated a desire to split their time into 2 5-minute presentations. The applicant should speak first and may reserve a portion of its time for rebuttal, as the applicant bears the burden of proof in this matter. It's before you for your deliberation.
Thank you, Mr. Berkey, and I understand that Mr. John Scott may be with us to represent the applicant. Are you there, Mr. Scott?
Mr. Chairman, I am. Chairman Neerman, Commissioner Lindley, John Scott for applicant. The proposal for decision correctly recommends the approval of the permit sought by the applicant. The law has been followed, the evidence considered in reaching the proper result. The ALJs had a tough job, but I believe they got it right. The ED and TCEQ staff have done a great job with the review and the permits it's crafting of the special conditions. The applicant chose not to file exceptions to the PFD and has worked with TCEQ staff to comply with the recommendations of the ALJ. The Commission's incredible effort to date on this matter and these permits has the Port of Brownsville and the community down there on the cusp of having a safe new facility that will stimulate high-paying jobs both during the construction phase and as we transition into the operational phase. I'm going to reserve the rest of my time for rebuttal if that meets with y'all's approval.
That works for us. Thank you, Mr. Scott. Commissioner Lindley, any questions or comments for Mr. Scott at this point?
Not at this point, thank you.
All right. Well, we'll hear next from the protestants. And Ms. Gaines, I think you're up for 5 minutes.
Good morning, Commissioner.
Good morning.
Thank you for having us. My name is Erin Gaines, here on behalf of protestant shrimpers and fishermen of the RGV. We have our lead counsel, Hannah Sampson, also on the line if there's any questions, from Texas Rio Grande Legal Aid, and Mr. Ilan Levine is also here. So you may be wondering why a local community group of shrimpers and fishers would care about this permit for a new refinery. The historic shrimp fork along the Brownsville Ship Channel is located directly across the ship channel from this proposed refinery. There's over 180 shrimp boats that dock their boats at the shrimp fork, provides over 1,400 jobs according to the Port of Brownsville. And members of our group, like Kyle Burnell, run a family business that have docked their boats at this historic shrimp fork for over 70 years. So the concerns in this case are very real for shrimpers members like Mr. Burnell. They're concerned about harms to their health, safety, and livelihoods. And they're concerned about the cumulative impacts from this proposed facility, along with 2 LNG export terminals that have already been permitted along the ship channel. The federal agency responsible for permitting those LNG terminals found that cumulatively they could increase ozone levels in the Brownsville area beyond federal air quality standards. And that was before taking into account Jupiter's ozone-forming pollution. Shrimpers believe this permit should be denied for all the reasons we've briefed. If the commission instead decides to grant the permit, there are two fairly modest changes or improvements that need to be added to the permit to satisfy the ALJ's fact findings. As you heard Mr. Scott say, the applicant Jupiter has already agreed to these two changes. And our position is if there's any uncertainty as to how to write these changes into the permit, the appropriate path would be a limited remand for that purpose. I'll briefly address the ALJ's first recommended change, the NOx limits for heaters and boilers, and then Mr. Levine will address the second recommended back change. As you know, Best Available Control Technology, or BACT, is a technology forcing standard that changes over time as technologies improve. As TCQ's own guidance says, it is, quote, not static. We've heard another party in this case use the phrase beyond BACT, and I want you to be wary of this. That's not the legal standard. BACT has to be evaluated case by case for each facility to ensure, quote, the highest level of control. And it must be justified in the record for this permit. So with respect to the ALJ's first recommendation that the smaller heaters at this facility should meet the same NOx limits as the larger heaters, we understand this issue to have been resolved as the ALJs explained in their reply to exceptions. First, the ALJs based this recommendation on the fact that Jupiter, quote, failed to justify permitting NOx emissions in excess of the limit in the back tables. And second, Jupiter has agreed to take this lower NOx limit on the smaller heaters, and the ED does not oppose this recommended change. I'll now pass it to Mr. Levine.
Thank you, Ms. Gaines.
Thank you.
Good morning, Mr. Levine.
Good morning, Mr. Chairman, Commissioner Lindley. May I start?
Oh, please do.
Thank you. Thank you. The second backed modification recommended by the ALJs has to do with optical gas imaging to enhance the leak detection and repair program. This is the other amendment or improvement to the permit that Jupiter has accepted and has is willing to take on in the permit. And you all have used optical gas imaging in some of your enforcement initiatives, so you're familiar with that, as has EPA. And of course, in the record, there are examples of other facilities using OGI. So this will provide that extra protection that the shrimpers and fishers of the Rio Grande Valley need. This helps ensure that leaks of volatile organic compounds are quickly identified and repaired. If there's any question at all as to how best to incorporate optical gas imaging into the permit, then the correct path forward is a limited remand to SOA for the purpose of recommending the proposed draft changes to the permit. And frankly, in the time since the PFD issued back in May and today, the parties probably could have worked out some language. We did reach out to staff, but we weren't able to get together on this. And we've also proposed language, and we've served that on the parties for how to incorporate OGI into the permit. A voluntary post-construction amendment or alteration to the permit to incorporate optical gas imaging, which is something that the staff, the ED has briefed, is entirely inappropriate. And it's for two reasons. First, per the ALJ's ruling, BACT is not satisfied without this improvement to the permit. So this permit cannot issue without this change. And secondly, we are a party in this proceeding, and we put on evidence and won this improvement, hopefully, in the permit. And we will not be given the opportunity to participate in a later alteration. So again, if there's any question on how to incorporate this change that Jupiter has accepted, the correct course is a limited remand solely for the purpose of, working out the language. Let me address one last issue, which is the allocation of the transcript costs. Let me just say that this is not about money, but it's really an important principle, and we implore you to correct this error. The protestant in this is Shrimpers and Fishers of the RGV, not my organization, not Ms. Gaines' organization. The Shrimpers are represented by their lawyers, Texas Rio Grande Legal Aid. That's a federally defined legal services corporation. Under the Texas Rules of Civil Procedure 145E2, Shrimpers are exempt from court costs. And again, that's because, as you know, legal aid organizations have income thresholds, and so they can only represent folks who meet those income thresholds. There are other reasons why the Shrimpers should not be assessed costs in this matter, but the really important principle and the wrong precedent would be to assess costs against a protestant that is represented by Legal Services Corporation, by legal aid. This was also a direct referral. The issues could have been wide open. We kept the hearing short. We wrapped up the hearing a day or two, at least a day early. We put on an efficient case, and we won on two modest but important improvements to the permit. So all those reasons, really, we should not assess costs against this party. In conclusion, let me just sum up our position. The permit should be denied for all the reasons we've briefed, but if it's granted, the best way to ensure that the two modest improvements that the ALJs have recommended and that the applicant has said they would do, if there's any question about how to incorporate those into the permit, a limited remand for the purpose of that drafting is how to do it. We will hopefully reserve time if there is any need for rebuttal, and look forward to any questions. Thank you.
Thank you, Mr. Levine. Commissioner Lindley, any questions?
No questions. Thank you both.
All right, thank you. Let's hear next from the Executive Director's Office. And I think that was going to be Ms. Browning. Are you with us?
I am. Can you hear me?
I can. Good morning.
Good morning. Good morning, Chairman, Commissioner Lindley, General Counsel, Public Interest Counsel. My name is Amy Browning with the Environmental Law Division, representing the Executive Director. With me and available to answer questions is Lyndon Poole of the Air Permits Division. For the reasons discussed in the ED's response and exception to the ALJ's proposal for decision as filed, the Commission should issue the permit to Jupiter Brownsville, including the adjusted NOx limit for heaters, and reject the ALJ's findings concerning the use of supplemental optical gas imaging to further monitor fugitive emissions. The ED does not agree that the ALJ's recommended NOx limit for heaters smaller than 100 million BTUs per hour is required to meet BACT requirements, but does not object to the inclusion of this limit in the permit, given that Jupiter has accepted this limit. The ED maintained his position that the review of the application and draft permit met all applicable statutory and regulatory requirements. ED staff performed the necessary review to ensure that the draft permit would meet all federal and state requirements and would be protective of the environment and human health and welfare. However, given the acceptance by Jupiter of the ALJ's proposed modifications to the draft permit with respect to the NOx emission limitations for the proposed heaters, the ED does not oppose the ALJ's proposed modification to the draft permit as related to the NOx emission limit. The ED does, however, note that the requirement in the permit for heaters smaller than 100 million BTUs per hour to use low NOx burners to meet the permitted emission limit may not be sufficient to meet the lower emission limit of 0.01 pounds per million BTU for NOx on an annual basis, as recommended by the ALJs, and Jupiter may have to seek appropriate authorization for any additional necessary control equipment. The ALJ's recommendation regarding OGI was based upon requirements for an entirely different industry, which is inconsistent with the guidance for determining BACT. The EPA's oil and gas regulations do not apply to refineries such as Jupiter. With regard to the single permit identified in the PFD, it is well settled that an applicant may propose controls that are beyond accepted BACT and may also propose controls to advance innovative technology that is not yet proven. The ALJ's recommendation that the application of BACT requires both LDAR and OGI is not BACT, is not consistent with TCEQ precedent, and should not be adopted in this case. The executive director accepts to the ALJ's recommendation to add OGI because the evidentiary record does not support a finding that OGI is BACT, and such a requirement also raises enforceability issues. The ED maintains his position that the review of the application and draft permit met all applicable statutory and regulatory requirements. ED staff performed the necessary review to ensure that the draft permit would meet all federal and state requirements and would be protective of the environment and human health and welfare. Thank you, and we are available to answer any questions.
Thank you, Ms. Browning. I have none. Commissioner Lindley, any questions for Ms. Browning?
No, thank you.
And we'll hear next from OPIC. Mr. Wayne, are you with us?
Oh, my apologies, Chairman. I did not unmute myself correctly. Good morning.
Good morning.
Chairman, Commissioner, Council, thank you. And also good morning to the Executive Directors, attorneys, and staff. I'm Sheldon Wayne with the Office of Public Interest Counsel. And here, OPIC agrees with the positions taken by the administrative law judges and supports issuance of the permit with the modifications laid out in the proposal for decision. In particular, we support the administrative law judges' analysis and conclusions regarding two specific ways the draft permit should be modified so that it is sufficiently protective. The emissions limits for the facilities fall for smaller heaters and use of additional optical gas imaging as control technology to reduce fugitive emissions. So now first, regarding those emissions limits. This facility is proposed to operate heaters and a boiler, including 7 heaters and boiler with firing rates above 100 metric million British thermal heating units per hour, and then 4 smaller heaters with firing rates below that 100 heating units firing rate. The draft permit allows these 4 smaller heaters to emit 3.5 times the amount of nitrogen oxides on an annual basis as the larger heaters, without any real justification for doing so found in the record. OPIC agrees with the administrative law judges that the evidence does not support the executive director's determination that these smaller heaters meet best available control technology, and therefore OPIC supports the judge's recommendation to revise the nitrogen oxides emissions limits so that those lower limits already included for the larger heaters would apply to all heaters. Second, regarding fugitive emissions, OPIC further agrees with the judges that the draft permit should be revised to include the use of optical gas imaging in conjunction with the 28 BHP leak detection and repair program. OPIC recognizes that this facility is permitted to emit a substantial amount of fugitive VOC emissions, over 459 tons per year, and optical gas imaging has been identified as an effective way to offset the deficiencies inherent in these LiDAR programs. OPIC agrees that the evidence in the record shows that optical gas imaging is technically practical and economically reasonable, and that without optical gas imaging, the draft permit does not meet the ACT for fugitive emissions. For these reasons, OPIC respectfully recommends overruling all parties' exceptions to the proposal for decision, adopting the judge's proposal for decision, and issuing the draft permit as modified by that proposal for decision. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Commissioner Lindley, any questions?
No questions, thank you.
All right. Mr. Scott, you have 9 minutes, I believe, for rebuttal. And I'd invite you to address the in your comments the issue of transcript costs, or if you don't want it counting against your time, you can address other matters, and I'll ask you that question. But I am curious about your client's position on the transcript costs.
Mr. Chairman, I'll address that first and foremost. I think, and I don't have my client's permission to say this, but I'm going to go ahead and go on the limb. I think that we would be willing to waive that provision. Our position at the time of the hearing, or my position, was very simply that they had not shown evidence that they were not capable of paying half those costs. And that was a position that the ALJs, also asking questions and listening to the arguments, agreed with ultimately.
If I can try to restate that, and I won't count this against your time, just so I understand where you are. It seems that the protestants have a policy objection to it. It's really not about the money. It sounds like it's not about the money for your client either, and it sounds like you're willing to assume all of the transcript costs just to settle this matter. Is that a fair reading of your comments?
Yes, Mr. Chairman, that's correct.
Thank you. And I ate into your time there a little bit, but go ahead, Mr. Scott.
No, and I really don't know how much of the issues specifically. I think Ms. Browning was perfect in her analysis of where we are. We're in lockstep with the ED on that. We don't believe there's any reason for remand, that any of the issues that are outstanding are things that the ED and the commission can take care of. And so for those reasons, we would ask that the commission adopt the ED's analysis of the ALJ's PFD and that permit issue. Thank you.
Thank you, Mr. Scott. Commissioner Lindley, any thoughts, questions, comments at this point?
Have we heard from everyone now? That's everyone, right?
We have, yeah.
This one's tricky.
Well,
I
there are
can
a lot
dive
of,
in,
there are
but
a lot of issues, and I have some thoughts prepared. I'm happy to
I'll let you
dig
tee it
into
off.
them.
Yeah,
And maybe we just, kind of take it issue by issue. So,
sounds good.
of course, in considering proposals for decisions such as the one before us, the Texas Government Code limits our authority. We do have the authority to change a finding of fact if there's a technical error, and we can change a conclusion of law if the administrative law judge did not properly interpret or apply the legal authority. But generally speaking, the ALJs are in the best position to evaluate the evidence and the credibility of the witnesses, and so we generally defer to their fact-finding judgment. On this item, just to show my hand, I am going to recommend that we adopt the PFD. I have a couple of minor modifications. I don't think they really change the substance of it, and I'll get into those later. But let's take this issue by issue, beginning with the ALJ's conclusion that the applicant met its burden to show that the draft permit complies with all applicable air quality standards. I don't see any record evidence that would support a change to the ALJ's findings or conclusions on this issue. I read the protestants' arguments more as a criticism of TCEQ and EPA guidance, as well as EPA's modeling tool, more of a critique of the authorities, I guess you would say, than whether the applicant appropriately applied those methods and authorities. So I would not make any changes on that issue. Let me pause there and gather your thoughts.
I'm in agreement as well.
Okay, and
I'll
then
keep them brief.
all right. Moving on PFD issue 2.1, the ALJs found that the applicant met its burden to show that the draft permit requires best available control technology or BACT for the heaters and boilers, except with respect to those small heaters that we had heard about. The ALJs recommend that all of the heaters, large and small, should have the same NOx limit that the draft permit proposed for the large heaters. And the applicant, as we heard, is not challenging that recommendation. So without opining on what BACT might be for a similar facility, for similar heaters at a similar facility, the proposed NOx limits in this case meet or exceed BACT, and I have no reason to disrupt the ALJ's recommendation on the small heaters either.
I'm in agreement. There really wasn't anything in the record that gave me pause. And, just to be very candid, I don't think the applicant, Jupiter, they didn't provide any evidence that it considered the SCR technology or the ultra-low NOx burners, so that wasn't in there, and they agreed to go on with it, so I'm okay with it.
Yeah, thanks for that. And your comments sort of foreshadow, some of the analysis that's coming from me, which is,
Yeah.
what
Yeah.
evidence is in the record and
Yeah.
who bears the burden.
Yep.
All right, so moving on to flares on issue 2.2, the ALJs found that the applicant met its burden to show that the draft permit requires BACT for flares, and they were not persuaded by the protestants' rebuttal evidence. They found no evidence that flare gas recovery systems have been required for similar authorizations, and that the claims that the other alternate flare designs might be more efficient, they found those suggestions to be speculative. So I would not disturb the ALJ's PFD on this point either.
I'm in agreement.
All right, moving on. That takes us to the question about BACT for fugitive emissions. It's issue 2.3. I'm actually going to come back to that later because I have quite a bit to say on it. So let's take up issue 2.4. That's the ALJ's determination that the draft permit is sufficiently complete to show that BACT has been achieved. The ALJs were not persuaded by the protestants' argument, that I think I misspoke there. ALJs determined that the draft permit is sufficiently complete. The protestants have raised this issue that Special Condition 73, which requires as-built design changes to be resubmitted for review, that makes the application somehow incomplete. And the ALJs rejected that argument. Design changes are common, they're routine, especially for large facilities, and the requirement to submit as-built changes is really to ensure compliance with our requirements, including BACT requirements. So I agree with the ALJs on that point and wouldn't change the proposal for decision on that point either.
I agree with you and the ALJs, yeah.
All right. Rolling on issue 3, the ALJs found that Dr. Aniagu performed an appropriate health effects review, both technically and legally, and determined that the public's health and welfare will be protected. The ALJs gave the testimony of the protestants' expert less weight, and I don't find any reason to disturb the ALJ's conclusion that the draft permit is adequate to protect public health and welfare.
I agree, yeah.
Okay, moving forward on issue 4, the ALJs find that the application and draft permit comply with the applicable requirements, including the filing of a complete application. They disagree with the protestants' argument that the application must be updated and consolidated to reflect all the changes made during the permitting process. And the ALJ's legal conclusion is correct. There is no such requirement. Representations made as part of the application are fully enforceable, whether or not they are consolidated into a revised application. Now, as a tangent, and this is really a process point, I do think that it's an open question and a very reasonable and fair question to ask whether this practice is as convenient or efficient as it might be. For example, in the context of a compliance review, can we do better here to serve the public, serve the regulated community, make things more efficient for the agency? I don't know that, so I'm going to ask staff to come meet with me and visit with me about that. But as to the matter before us, the legal issue, I don't see any reason to disturb the ALJ's work on this issue either.
I'm in agreement.
Okay. Next up, transcript costs. I came in here prepared to say something else, but it sounds like the applicant has agreed to bear all the transcript costs, and so I intend to make a motion that conforms with that.
I'm comfortable with that.
Okay.
Mm-hmm.
And that brings us back to BACT for fugitive emissions. And I earned my pay on this one.
Mm-hmm.
This is a lot to work through.
It was.
So So here's my analysis. Yeah, I think that the applicant made their prima facie case that its use of TCEQ's 20H VHP leak detection and repair program, or LDAR program, constitutes BACT. And they did that with a simple demonstration that the 28 VHP program is listed on the Tier 1 BACT tables. Protestants offered evidence and a lot of argument in rebuttal. I did find much of it misplaced. The protestants argued for a more stringent 28 MID LDAR program, as well as for leakless valves and sealless pumps and compressors. All of that goes well beyond BACT requirements. It would not be required for authorizations in an attainment area. Protestants also argue that optical gas imaging, or OGI, should be used as an alternative. I think in some places it was articulated as an alternative to, in other places it was articulated as a supplement to the LDAR requirement. They cite federal regulations at 40 CFR Part 60 Quad O-A, which requires OGI for upstream and midstream natural gas facilities such as gas wells and compressor stations. These are very different facilities from a petrochemical refinery. And so on this argument, I disagree with the ALJs that Quad O-A is competent rebuttal evidence for the proposition that OGI might be economically reasonable at the proposed Jupiter plant. The protestants also cite an academic argument addressing OGI for detecting leaks of methane. And as a reminder, methane is not a VOC. They also cite materials prepared by a vendor of OGI equipment. In my view, the ALJs give these materials too much weight. They don't speak to the economic reasonableness of OGI as BACT for volatile organic compounds at plants similar to the proposed Jupiter plant, and they're not competent as rebuttal evidence. And then finally, the protestants argue that the use of OGI at Motiva's Port Arthur refinery is evidence that OGI is technically feasible and economically reasonable at the proposed Jupiter plant, and the ALJs seem to agree. Now, I'm not convinced of that. I'm far from convinced. I doubt that BACT actually requires OGI in this case, but the proper analysis in this case is really driven by the burden of proof. And so if you follow commission rules pertaining to the burden of proof, and I'm referring specifically to 30 TAC section 80.17C, it's the applicant that bears the burden, and if the protestants lodge competent rebuttal evidence, the applicants or the ED are compelled to answer that. Under a Tier 1 BACT analysis, staff is required to go beyond simply the table and consider any information that they may have that bears on the question of feasibility and reasonableness. And the mere fact that OGI is used at Motiva's refinery is, in my mind, adequate rebuttal evidence to the applicant's prima facie case. They didn't give us a lot to work with. There wasn't a lot of discussion of why it was feasible or reasonable in this context. So it remains an open question, but I think they did succeed in rebutting the prima facie case. And also note the Motiva refinery is similar to the Jupiter refinery, and both would be in attainment areas. So in its exceptions, the executive director argues that the use of OGI at Motiva doesn't automatically make it BACT for all similar facilities. And I think that's true. It's not. But that argument doesn't really begin to answer the question of whether or not OGI is technically feasible or economically reasonable at Jupiter's proposed plant, given the experience with OGI at Motiva. So In fact, if I didn't say this already, let me repeat. I didn't see any evidence offered by the executive director or the applicant to answer the protestants' rebuttal. I think the protestants' rebuttal is not fulsome. I'd like to know more about Motiva's refinery, but I don't think we need to answer this question. It's the applicant that bears the burden of proof. The applicant failed to rebut evidence that OGI should be added to the 28 VHP LDAR to achieve BACT for fugitive VOC emissions. And so that's where I come out. I do want to note that, as we heard, the applicant has elected not to challenge the ALJ's recommendation to require OGI. I think it's appropriate for us to include that in the authorization. But I want to point out that I think this is different from saying that BACT requires OGI. Instead, I would say that the inclusion of OGI settles this issue and answers any legitimate concerns about BACT. So that was a lot, but let me pause there and gather your thoughts on this VOC fugitive emission BACT issue.
You did earn your pay, and I'm appreciative of it. So I was looking at kind of points I wanted to make and checking them off as you said them. So I'm actually very much in agreement with, I think I'm in complete agreement. Let me just say it that way. I will say I went back and forth on this issue. This time yesterday, I probably didn't feel the same way as I do today, but today I am comfortable adopting the PFD, and it comes down to all the reasons you just listed. Where I had a hold up yesterday was on the this issue of BACT for VOC or fugitive VOC emissions. I didn't want to do anything precedent setting, make a decision that might be interpreted later down the line as precedent setting and making OGI a requirement. But I think you've laid everything out very well and very clearly. And at the end of the day, what it came down to for me is that, like you said, the applicant failed to offer any rebuttal on why that shouldn't be a requirement, I guess would be the best way to say it, and why OGIC shouldn't be used. And they said, yeah, we'll do it, we accept it. And so I'm comfortable. We might have to tweak a little bit of the PFD. I'm not sure where it stands at this point, but I'm comfortable. Maybe not. Maybe it's fine how it is.
And I looked at that. What I think we need to do, or what I would propose, is just a couple of small edits, just to reflect, reflect the slant of my analysis. I don't think it's going to change any of the requirements in the permit ultimately, and I can lay those out for you.
And I will just say, I'm appreciative, I guess, I don't know if appreciative is the right word to use, but I appreciate that Mr. Scott acknowledged that the applicant would be willing to pay the fees, so that issue is also dealt with today as well. So I'm comfortable, I'll say this, moving forward, adopting the PFD with whatever little tweaks you have, more than likely.
Okay, great. And one thing that I want to respond to that you said is, the sensitivity about saying what BACT is definitively for these kinds of refineries. I was really sensitive about that issue too, but it is absolutely true that BACT is dynamic. It's an evolving thing, and so I think what's important is the question, for future refineries, what is the experience at Motiva? What will the experience be at Jupiter? Has it proven itself to be technically feasible and economically reasonable? That maybe yes, maybe no. We'd like to see some evidence on that the next time it comes to us, and whether we see it or not, we have a framework in terms of the burden of proof analysis for resolving the issue. All right, so let me try to piece together a motion here.
I'll let you do that.
And we can dispose of this item. All right, I think I've got it. And let me preview part of the motion before I dive into it. I'm going to propose two edits, one to finding of fact 67, one to conclusion of law 14, just to better reflect the analysis that I laid out, including the significance of the applicant's agreement to the heaters and especially to OGI. And then I'm also going to, without providing language, just direct that finding of fact 93 and conclusion of law 21 and ordering provision number 2 be modified with the effect of requiring the applicant by agreement to pay all transcript costs. So turning back to finding of fact 67, it says, quote, to meet BACT, the draft permit should be revised so that OGI is required. I would replace that introductory phrase to meet BACT with the following, quote, given the agreement of the applicant, end quote. So same substantive outcome, just a little bit different slant on the justification. And then on conclusion of law 14, I would add language at the end of that conclusion, again, just to point out the role of the applicant's agreement in our analysis. All right, so with all that, here's the motion. Commissioner Lindley, I move that we adopt the administrative law judge's proposed order, but modify finding of fact 67 so that it reads, quote, given the agreement of the applicant, the draft permit should be revised so that OGI is required to augment 28 VHP LDAR system, end quote. And modify conclusion of law number 14 by adding, quote, and with the agreement of the applicant, end quote, at the end of the sentence before the period. And I further move that we modify finding of fact 93, conclusion of law 21, and ordering provision 2 to require the applicant to pay all transcript costs. And that ends my motion.
Before I
You
second,
want a
can I
minute- you want
talk?
a minute
Yeah.
to confer? Yeah.
Yes, please. I second your motion.
All right. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you, counselors, for being here this morning. Appreciate it. And with that, Mr. Berkey, I'll ask you to please call the next item.
Item number 2 is the hearing request determinations for the application by Astra Investments 1 LLC and Sandfield Limited Partnership for new TPDS permit number WQ 0015901001. The parties have been notified that the commissioners will not take oral argument, but they may ask questions, and the matter is before you for deliberation.
Thank you, Mr. Berkey. For those who are not familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming at least one requester meets the requirements, we then consider which issues are referred for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. And Commissioner Lindley, on this item, we received 2 requests. The first by Justin Alexander Gallo and Emily Gallo. They live approximately 600 feet from the proposed facility. They raise concerns about harmful impacts to their water supply, among other concerns. They've also met the procedural requirements to be granted a hearing, so I would grant their request. The second is from Michael and Kimberly McCary, but they failed to provide an address and will often allow requesters to cure this in a reply, but the McCarys did not file a reply, so we're compelled to deny their request. So that's where I landed on the parties.
I'm in agreement.
Okay, moving to the issues. We refer issues that are raised consistent with the procedural requirements and that are legally relevant and material to the permit. In other words, they have to be within the commission's jurisdiction for this type of permit. So on a wastewater discharge permit, we're prohibited from considering air emissions. Those would be the subject of a separate air authorization if one were required. We can't consider noise, property values, and so on. So I ultimately found two referable issues. The first is whether the draft permit is protective of groundwater and water wells, and the second is whether it is protective of the requester's health and the health of their family. So that's it for the issues.
Yeah, short list, but I'm in agreement.
And then I think it'd be appropriate to allow a hearing duration of 180 days and also to include an ADR
Yeah,
referral.
I'm in agreement. I will move that we grant the hearing request of Justin Alexander Gallo and Emily Gallo, excuse me, deny all other hearing requests, that we refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit is protective of groundwater and nearby water wells in the area. And Issue 2, whether the draft permit is protective of the health of the requesters and their family. That we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we set the hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Thank you for that. The motion has been made and I second it. All those in favor say aye.
Aye.
The motion carries. Mr. Berkey, please call the next item.
Item number 3 is the hearing request determinations for the application by the City of Liberty Hill for renewal of TPDS permit number WQ0014477001. The parties have been notified that the commissioners will not take oral argument but may ask questions. I do want to acknowledge that a large number of interested persons have signed in on this item, and your attendance will be noted in the official record on this matter. The matter is not posted for public comment, but again, your attendance will be noted and is appreciated. And this matter is before you for your deliberation.
Thank you, Mr. Berkey, and I'll add my thanks to all of the folks who are here, both in person and online, to participate. Commissioner Lindley, again, we follow a two-part analysis for considering requests for contested cases. Part 1 is about who's entitled to a hearing, and Part 2 is about which issues are referred. There is, however, a threshold question, and that is whether there is a right to a contested case hearing given the exception for no increase renewals at Texas Water Code Section 28.028D. And that provision provides that there is no right to a contested case for renewals where, among other requirements, there's no significant increase to the quantity of waste authorized to be discharged, and the applicant's compliance history for the previous 5 years raises no issues regarding the applicant's ability to comply with the material term of the permit. Over the past 5 years, there have been 2 notices of enforcement and a dozen notices of violation. I think the city's compliance history does in fact raise an issue regarding its ability to comply with a material term of their permit. So I think we clear this threshold question and continue with the analysis. I do want to mention, as we've discussed before, that a compliance history classification is not dispositive on this question, even if the performance were classified as satisfactory or a high performer. So any thoughts on the no increase renewal issue?
I'm in agreement. I think the threshold has been met because of compliance history issues, so, yeah.
I think it was a pretty easy one.
Yeah.
Honestly. All right. Again, requesters who are affected in a manner different from the general public who have articulated personal concerns that are relevant and material to the permit and have done so in timely comments and a timely hearing request are entitled to a hearing. I counted about 29 requests in this case. 6 of the requesters are for persons who reside within a mile downstream of the discharge point, and they've raised personal concerns that are relevant and material to the permit. 5 of the 6 also met the requirement, all the procedural requirements. And let me read their names. They are Sharon Cassidy, Terry Ira Cassidy, Stephanie Morris, Daniel Woodbridge Morris, and Jeff Wiles. So I would grant their requests. The 6th requester in this group, Ms. Erickson, did not file comments during the comment period, and so we're required to deny her request. 10 requests are from people who live on the discharge route just under 4 miles downstream from the discharge point. And normally this is well beyond the point where requesters' interests would be distinguishable from an interest common to the general public. But these requesters submitted evidence of algae growth at their properties, affecting their enjoyment of their properties and their recreational interests, and additionally evidence that the algae is not present upstream of the city's discharge point. And so I think it raises a question: are these affected persons, or are they indistinguishable from the general public? And I think it's an open question that's going to require some evidence. You know, I'll point out that there are some intervening tributaries between the discharge point and their properties. There may be other factors at play here, and I'm going to propose that we kick that over to SOA and have them sort it out. In other words, I would refer these requesters for an effectiveness determination, so long as they've met the other requirements to be entitled to a contested case. And I can list those names, but let me pause there and see how you feel about that analysis, because this is
It is a little
quite a bit
different,
different
yeah.
from what from a normal approach here.
I agree, it is different, but the evidence was pretty compelling. I mean, it's kind of what it came down, or what was in the record was pretty compelling as far as there isn't a good point, and so it is an open question. So I would be comfortable sending, not quite all 10, but a good amount, and I'll wait and see what names you have on your list for an effectiveness determination.
Yeah, there were, let's see.
Or I can read who's on my list, whatever's easier.
Yeah, why don't you do that? I'll take a break from talking for a minute, and I'll cross-reference to my list. But I think there were 3 that failed to express personal concern, or they expressed only generalized concerns. So I eliminated those. I imagine you may have landed in the same place. But
Probably the 7 I have are John and Carolyn Ahrens, David and Louise Bonnell, Gerald and Susan Harkins, Carol Hawley, Jessica Jensen, Lawan Toll, and Mark Tummins.
yeah, that's
Tumins, excuse me.
that's who I had on my list as well. So I would deny the remaining requests of that group of 10. And then there were 13 more requests to round out the 29, and they're from folks who reside more than a mile from the facility and who do not reside on the discharge route. And in that case, I think their interests are indistinguishable from the general public.
I'm in agreement.
And some of that group failed for other reasons, failing to identify personal issues and so forth. So I would grant, I think we said 5 plus 7, 12 of those requests, right?
That's what I have.
Okay. All right. Well, it sounds like we're on the same page on the parties. On the issues, I've organized them into 11 relevant and material issues for referral. And let me tick through those and see if we landed in the same place. The first is whether the draft permit is protective of water quality, including groundwater and the receiving waters, whether it is protective of the health of the requesters and their families, whether it is protective of wildlife, whether it addresses nuisance issues consistent with commission rules, whether it is protective against excessive algae growth and complies with the aesthetic requirements in the commission's rules, whether the draft permit should be denied or altered based on the applicant's compliance history, whether it should be denied or altered in consideration of the policy of need as that's articulated under Texas Water Code, section 26.0282, whether it complies with anti-degradation requirements, whether it includes appropriate provisions for operator licensing and supervision, whether the draft permit is protective of the requester's use and enjoyment of their property, and finally, whether it includes sufficient monitoring and reporting requirements.
I'm in agreement.
All right, and I think the only other things I would add is hearing duration. I would allow the whole
Yeah.
180 days. There were some requests for reconsideration that really didn't raise any new information, and so I would deny those.
I'm in agreement. I wish that was a motion so I could just second it. I think that covers everything. We're
I'm
not
talking
doing.
way too much during this meeting.
Well, I'm appreciative. I'll say that. I don't think ADR is appropriate on this one. It's just a few too many parties.
Yeah, that could be arranged ad hoc. I don't know
Yeah.
that we need to include it in a motion.
Well, I will attempt a motion here. I will move that we grant the hearing requests of Sharon Cassidy, Terry Ira Cassidy, Stephanie Morris, Daniel Morris, and Jeff Wiles. That we refer the hearing requests of John and Carolyn Aarons, David and Louise Bennell. I apologize if I'm mispronouncing names as well. Gerald and Susan Harkins, Carol Holly, Jessica Jensen, Lawan Toll, and Mark Tummins to SOA for an effectiveness determination. That we deny all remaining hearing requests and requests for reconsideration. That we refer the matter to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of water quality, groundwater, and uses of the receiving waters of the South Fork San Gabriel River in accordance with the Texas Surface Water Quality Standards, including recreational use and with consideration of the maximum volume of the proposed discharge. B, whether the draft permit includes adequate provisions to protect the health of the requesters and their families and aquatic and terrestrial wildlife. C, whether the draft permit adequately addresses nuisance conditions, including odor, in accordance with 30 Texas Administrative Code 309.13E. D, whether the draft permit includes appropriate provisions to protect against excessive growth of algae and comply with the aesthetic parameters and requirements of 30 Texas Administrative Code, Chapter 307.4, including aquatic nutrient limitations. E, whether the draft permit should be denied or altered based on the applicant's compliance history. F, whether the draft permit should be denied or altered in consideration of the need for the facility in accordance with Texas Water Code, Chapter 26.0282, consideration of need and regional treatment options. G, whether the draft permit complies with applicable anti-degradation requirements. H, whether the draft permit requires adequate licensing requirements for the operator of the facility and adequate requirements regarding operator supervision. I, whether the draft permit includes adequate provisions to protect the requester's use and enjoyment of their property. And J, whether the draft permit includes sufficient monitoring and reporting requirements, including necessary operational requirements, and that we specify the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
Thank you for that. The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries. Mr. Berkey, please call the next item.
Item number 4 is a hearing request determinations for the application by Diamondback Recycling and Sanitary Landfill, LP, for new MSW landfill permit number 2404. The parties have been notified that the commissioners will not take oral argument, but may ask questions. The matter is before you.
Thank you, Mr. Berkey. Once again, we follow a two-part analysis. Part 1 as to who gets the hearing, and Part 2 as to which issues are referred. Commissioner Lindley, in this case, Knox Real Property, LLC, and Jason Harrington own property surrounding the proposed facility, and they've requested a hearing citing, among other concerns, nuisance odors and also interference with a planned public water supply well, which I think implicates concerns about contamination of groundwater. These pretty clearly constitute personal justiciable issues, and so I would grant these requests. Next up, Moss Dean Ranch, Betty Moss Dean, and the CA and Betty Moss Family Limited Partnership have requested a hearing citing concerns about nuisance odors and the safety of drinking water wells, among other concerns. They have identified property within a quarter-mile of the proposed facilities, and so I think they have also demonstrated a personal justiciable issue, and I would grant these requests as well. We had a request from Ashraf Salim and Sorup Investments. They assert a planned investment in neighboring property, but they failed to identify the relevant parcels. They provided, the only address they provide is in Grand Prairie, which is hundreds of miles away. So bottom line is they fail to meet the procedural requirements for a contested case, and we're compelled to deny that request. And the only remaining requests were withdrawn. So that's my take on who gets a hearing in this case. And let me pause there and collect your thoughts.
I'm in agreement on the parties.
Okay. Turning to the issues, and I just have to say there was some highly effective lawyering in this case, because this is these lawyers, in my review, got a high
Someone's
score,
earning their
high score for the number of issues that I thought were relevant material and that we'll be
There are a number.
referring over. They are what you would normally expect to see in an MSW landfill permit. I suspect, hope that we largely came out in the same place. So what I'm going to propose is that we not read them twice.
Okay.
I'll read them into a motion,
Okay.
and then to the extent that
If I'm in agreement,
to the
I
extent
will.
that there's any differences, hopefully we can sort it out through a friendly amendment and won't have to read it twice. But
Okay.
we'll cross that bridge when we get to it. There are some pending requests for reconsideration, but they don't raise any new issues for us to consider. So I would deny those. I would include an ADR referral on this. I think it makes sense since we have a limited number of parties. Since we have so many issues, I would allow the
Agreed.
full 180 days. A little wrinkle in this one. I'm not sure if that's the right word, but we have a request for a hearing on takings, and which we don't often see.
Mm-hmm.
And my analysis of that is we haven't taken any action yet. No permit is issued, and so there is no takings yet. So in short, that request is not yet ripe.
I agree.
So I think that covers the issues that I'll wrap into a motion.
I will. Sounds good.
Okay. So, Commissioner Lindley, I move that we grant the hearing requests of Knox Real Property Development, LLC, Jason Harrington, Moss Dean Ranch, Betty Moss Dean, and CA and Betty Moss Dean, FLP, filed pursuant to Texas Water Code, Chapter 5, and Texas Health and Safety Code, Chapter 361. I further move that we deny the remaining requests for hearing and requests for consideration filed pursuant to Texas Water Code Chapter 5 and Texas Health and Safety Code Chapter 361. I further move that we find that Knox Real Property Development LLC's request for a taking hearing is premature, as there have been no final decision by the Commission on whether to issue a permit to Diamondback. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program concurrent with the SOA's preliminary hearing schedule process. And I move that we refer the application to SOA for a contested case hearing on the following issues. A, whether the applicant has demonstrated a sufficient property interest as required by TCEQ rules. B, whether the application includes a sufficient odor control plan. C, whether the application includes a sufficient land gas management plan. D, whether the applicant has sufficiently demonstrated evidence of competency as required by TCEQ rules.
I have one quick comment on
Yeah.
C. You had just said land gas management plan instead of landfill, but I know what you meant.
Yeah, I misspoke. Landfill gas management
Yeah,
plan.
That's what I heard, and you might have even said correct, but just for the record.
Okay, thanks for that. I'm going to
And
continue.
D, I was in agreement with what you said for the demonstrated evidence of competency.
Okay, for clarity, let me repeat by picking it up at C, whether the application includes a sufficient landfill gas management plan. D, whether the applicant has sufficiently demonstrated evidence of competency as required by TCEQ rules. E, whether the proposed facility is a compatible land use. F, whether the roads used to access the facility site are available and adequate. G, whether the proposed design and operation of the landfill liner meets all applicable requirements. H, whether the proposed design and operation of the landfill cover meets all applicable requirements. I, whether the applicant has adequately addressed potential seismic impact zones at the proposed facility. J, whether the applicant has provided an adequate wetland delineation and adequately addressed potential impacts of the proposed facility on wetlands. K, whether the applicant has provided an adequate delineation of the relevant floodplains and floodways and adequately addressed potential impacts of the proposed facility on floodplains and floodways. L, whether the applicant has demonstrated that the design and operation of the facility includes sufficient measures for erosion control and prevention. M, whether the applicant has provided a sufficient surface water drainage report. N, whether the applicant has adequately addressed endangered and threatened species as required by TCEQ rules. O, whether the application adequately delineates and addresses easements. P, whether the applicant has proposed adequate waste screening measures. Q, whether the applicant has demonstrated that the landfill is protective of groundwater. R, whether the applicant has provided an adequate site operating plan. And finally, S, whether the application and draft permit have adequately addressed the oil and gas water well provisions in 30 Texas Administrative Code, Section 330.61L. And I would further move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued. And that's the end of my motion.
I'm going to second it and hope you don't have to repeat any.
Okay, I heard a second. I'm going to take it. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Mr. Berkey,
Chairman,
can I have a
Commissioner,
sidebar?
I'm going to recommend that we take a 5-minute break to address a technical issue.
All right, fair enough. With that, the time is 10:38, and we stand in recess for what I hope is a short break.
Megan's having difficulty hearing you. Okay, so go find out what's going on.
All right.
I don't think that'll be necessary. Hey, Todd. Mike. You too. How you doing? It's been a little while. Great. Good to see you. How's the family? Oh, all good. Awesome. How are you doing with your family? I'm fine. Still at home. Thanks very much. My girlfriend works at Adult Children, so basically in my dining room, just by myself and my dogs.
Oh my gosh, well, you're here today.
Here today.
This is my first time in a couple of years.
Yeah.
It's kind of fun just to get out.
Sure, yeah. Put a suit on again.
Yeah, no kidding, no kidding.
But everything good at the firm?
That's
Jay's
all,
doing
yeah.
well?
Jay's doing great, just blowing and going, and, we're, we're busy.
Awesome.
Got me a few issues to go prove up now.
Good to see you.
Take care, Tom. Thank you.
Dina, can you hear me?
I can hear you, Megan. Can you hear us?
Testing, mic, test, test.
Okay.
Got a thumbs down. Testing, Mike.
I know on the agenda there's a phone number listed, because I was
Yeah.
looking at it last night. It
Yeah.
had like 3 options.
Mm-hmm.
Okay.
I'll go talk to him.
Oh, okay.
Test.
Could it be their platform? Is it yeah, I have that on there, but I don't have like, I haven't emailed Keisha to get the freaking sticker.
Not on YouTube.
Oh, that makes me feel better, yeah. That makes me feel better.
They already use it.
Oh. Same with, my text tag.
Yeah.
Well, same with my text tag, I haven't done that either. And,
That's already.
Dad keeps harassing me, he's convinced that someone's gonna be using it, and I was like, I don't think that's how it works. I was like, I'm pretty sure it goes along with your your license plate. So yeah, baby, yeah, okay.
Testing, Mike, testing.
Our text tags from our old cars and put them on our new ones, they weren't new. Yeah, they don't work. Ken was like, they used them, like, yeah, they got smarter. Little nugget, slept okay? Not really, no, but Kevin was like, on it last night, which was very nice, but. Anyhow. Pretty sure as soon as I leave her, I'm gonna come. But right now, I'm like. Yeah. Well, I immediately got a text from Stephanie and Shayna. Oh, yeah. They're like, holy cow, your boss is a beast. What is she doing? Extenuating circumstances. Sorry. We're impressed. Hey. Oh, okay. That's Bob. Janeka just texted me. Oh, no, I know. Thank you. Bye. YouTube's still working. Like, you can hear us.
Try me again. Can you hear me?
Don't know.
Is there someone
I can hear you.
Problem with the webinar is that the webinars, several problems, but it's not working. We can't make an announcement on the webinar to switch over to YouTube or
Well,
online.
everyone can hear Megan. The
Okay.
only thing that can't be heard is the dais at this point in the webinar.
Okay.
The telephone line is up,
Yeah.
so there is a possibility,
Was there-
if we want to instruct, there are 2 members.
Is it
Mic test, mic test.
Okay, Todd.
Mic test, mic test.
Mary, can you hear me? Yeah, can you hear me?
Hi, Megan. I'm not sure if you said
Megan, I can hear you.
but I can hear you.
Okay, thank you. Please, thank you, Dina.
Mic check, test check, check.
Scott, test the microphone again.
Yeah, they're driving up to you.
Mic test, mic test.
I'm driving the whole thing
Oh, wow.
because I got all the camping gear in the car. But
Wow.
Lucy and Stephanie are flying to New Mexico. They're going to meet me there
Gotcha.
Saturday. So
Beautiful though. What is the temperature at night? Oh, man, that's gonna be awesome. Oh, that's so cool.
Todd, try again.
Mic check, mic check. Mic test, mic test.
Good morning, everyone. We're having technical difficulties and there's no audio available at the time. If you'd like to continue to listen to the meeting and you want to participate in the meeting, you can switch to your audio, the phone audio by going to your panel on the right and clicking audio and clicking the phone call button. And it will give you a phone number, an access code, and an audio pin. If you would just like to view the meeting and you don't want to address the commission, you can go to our YouTube channel and the link is available on the screen. If you're calling in and you plan to address the commission, you will be in listen-only mode and I will unmute you when they call your name.
I know that, I almost did it, but I was like,
Yeah, exactly.
better than that.
You want me to shut off the audio?
Carrie, can you hear me?
Yes, ma'am. Can you hear me?
Okay, thank you, yes. Mr. Howard, can you hear me?
Can you hear me? This is
Yes,
Nicholas
ma'am.
Howard.
Great, thank you.
All right, folks, we're back on the record. The time is 11:11 a.m. After a break to try to sort out some technical issues, and I'm going to try to recap where we are on those. There's several ways to access this meeting. One is through our YouTube channel. If you simply want to watch but not speak, you can do that, and that link is on our agenda notice. People who wish to participate in the meeting, who are not here in the room, not in person, they want to do it virtually, they do that through the GoToWebinar platform. And that's the platform that we had a problem with, and we lost our audio on that platform. There's actually two ways to access audio through that platform. One is a web-based audio. That's what failed. The other is by dialing in and getting your audio over a phone line. That did not fail. That's up and running. And I think we've succeeded on getting most of the parties and other participants moved over to that phone line. And I believe there may be some instructions up on your screen if you're watching this on GoToWebinar, instructions as to how you find the phone number and the access code, and the audio pin in order to join by the telephone. So I think almost everybody has succeeded in doing that, so I think we're ready to carry on here. So that's where we are with the technical issues. I understand that YouTube continued flawlessly. YouTube captured the entire motion on the last item. GoToWebinar did not. We cut out in the middle of that motion. So we're going to do belt and suspenders here. So I'm going to make the motion again. We'll finish up with this item, and then carry on. So with that, Commissioner Lindley, on item 4, I move that we grant the hearing requests of Knox Real Property Development, LLC, Jason Harrington, Moss Dean Ranch, Betty Moss Dean, and CA and Betty Moss Dean, FLP, filed pursuant to Texas Water Code Chapter 5 and Texas Health and Safety Code Chapter 361. I further move that we deny the remaining requests for hearing and requests for reconsideration filed pursuant to Texas Water Code Chapter 5 and Texas Health and Safety Code Chapter 361. I further move that we find that Knox Real Property Development, LLC's request for a takings hearing is premature, as there's been no final decision by the Commission on whether to issue a permit to Diamondback. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program concurrently with the SOA preliminary hearing scheduling process. And I move that we refer the application to SOA for a contested case hearing on the following issues. A, whether the applicant has demonstrated a sufficient property interest as required by TCEQ rules. B, whether the application includes a sufficient odor control plan. C, whether the application includes a sufficient landfill gas management plan. D, whether the applicant has sufficiently demonstrated evidence of competency as required by TCEQ rules. E, whether the proposed facility is a compatible land use. F, whether the roads used to access the facility site are available and adequate. G, whether the proposed design and operation of the landfill liner meets all applicable requirements. H, whether the proposed design and operation of the landfill cover meets all applicable requirements. I, whether the applicant has adequately addressed potential seismic impact zones at the proposed facility. J, whether the applicant has provided an adequate wetland delineation and adequately addressed potential impacts of the proposed facility on wetlands. K, whether the applicant has provided an adequate delineation of relevant floodplains and floodways and adequately addressed potential impacts of the proposed facility on floodplains and floodways. L, whether the applicant has demonstrated that the design and operation of the facility includes sufficient measures for erosion control and prevention. M, whether the applicant has provided a sufficient surface water drainage report. N, whether the applicant has adequately addressed endangered and threatened species as required by TCEQ rules. O, whether the application adequately delineates and addresses easements. P, whether the applicant has proposed adequate waste screening measures. Q, whether the applicant has demonstrated that the landfill is protective of groundwater. R, whether the applicant has provided an adequate site operating plan. And S, whether the application and draft permit have adequately addressed the oil and gas and water well provisions in 30 Texas Administrative Code, Section 330.61L. And finally, I further move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Mr. Berkey, please call the next item. Apparently, we're continuing to experience technical difficulties, this time with the phone line method of accessing GoToWebinar. So we're going to continue working on these issues. And with that, the time is 11:19 a.m. and we stand in recess again.
Ron, can you hear me?
I
Yes,
heard that.
I can hear you.
Thank you.
Oh, Ron. Sorry.
Mic test, mic test.
Yes. Yes.
Did you, hey, Ron, did you hear Todd?
Oh, Ron. I don't know if I heard Todd. I heard the chairman.
Oh,
This is Todd, mic test, mic check.
Mic test, mic test.
who just said mic test?
No, I don't think I heard Todd.
I didn't either. Who just said mic test?
This is Todd, mic test from Todd.
I heard that.
Thank you.
Mic test, this is Emily. Can you hear me?
Todd, can you try one more time, please?
Todd, mic test, Todd, mic test.
Please enter your access code followed by the pound or hash sign. To enable audio control, please muted.
Todd, mic test. Todd, mic test.
All right, well, welcome back. It is 11:29. We're back after yet another recess to sort out our technical difficulties, and we're still struggling with that. So I've visited with my lawyers, and not all of them, Mr. Berkey, but some of them, and Commissioner Lindley. I think our a potential path forward. I think item 4 is done and closed with not one but 2 motions, belt and suspenders. And I think the best path forward, so we don't have confusion about these later items, is to continue them to the next agenda. But we're just double checking right now to confirm that there's nothing that's time sensitive on those.
So that's 5 through 26.
Yeah. Right.
And I guess
5 through the end of the enforced.
Yeah.
And then I didn't see any need for an executive session.
No,
I understand
I guess we would also, public comment session would happen.
Right, and that's a
next.
particular issue because we do have somebody who wants to make a public comment, and there are concerns that our connection with that person is not reliable.
Gotcha.
So we would invite them back to make their comment and take any other public comments.
I see.
At the next agenda. So I'm going to propose that we just hang tight for a second, wait till I get confirmation that we don't have any time-sensitive matters, and then we can act accordingly.
Sounds good. Thanks for
Yeah.
working on that.
All right, Commissioner Lindley, Mr. Berkey, I just spoke with Ms. Smith, our general counsel, and she's checked with all the relevant staff, and nothing on the remainder of the docket is time sensitive. So Commissioner Lindley, I'm going to move that we continue items 5 through 8. Item 9 has been remanded, and that we continue items 10 through 27 to the next agenda.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Mr. Berkey, let's call the next items.
Items 28 to 31 are posted for closed executive sessions, and the commission will not meet in closed session today.
With that, the time is 11:37, and we are adjourned.